Friends, I welcome you all at Swayam platform. I am Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University. I welcome you all in a 7th week of our course, Hindu Personal Law, including marriage and succession. In the last week, we started discussion on succession, where we try to understand the general observation about the Hindu Succession Act. We also understand the Kopasnar and Kopasnari. We also understand the joint Hindu family. We also discussed about the section 6 dissolution of the interest within the Kopasnari. And we also discussed the Hindu male intestate succession. Succession in a case of Hindu male dying intestate. Friends, we discussed section 6, 8, 9, 10, 11, 12, 13. And by this discussion, we understand the fundamental rule of succession and special rule of succession in a case of Hindu male dying intestate. In this background, today I am going to start 7th week, and the title of this week is Hindu Succession Act Part 2nd. In this week, we try to understand the remaining portion of Hindu Succession Act. We will discuss the property of Hindu female. We will discuss the special rule for Hindu female dying intestate, and we also discuss the general rule relating to succession, disability in reference to succession, and section 22 of the Succession Act. This is the scheme of the 7th week, and in the light I am going to start the discussion on the first lecture of the 7th week, that is the property of Hindu female. Friends, property of Hindu female is a controversial topic, because one of the narrative is there was no property right was available to the women, and by this discussion the learner will able to understand certain point. Friends, the first one is the meaning and concept of Stridhan, nature of property of Hindu female, various kind of property under section 14 subclass 2 to which Hindu female has restricted right, and difference between the restricted estate and limited estate. So these are the learning objectives of the today's lecture, and the student will able to comprehend each and every dimensions related with Hindu woman's property. Friends, when we think about the property of Hindu women in India, we are bound to consider the idea of Stridhan, because modern legislation, that is Hindu Succession Act under section 14, also included the term Stridhan. Therefore, friends, what is Stridhan is required to be explored for two purposes. For the purpose to understand section 14 in complete sense, and on the other hand to break the narrative which was prevalent that Hindu woman had no right in Shastric Hindu law. And in the light of this, I want to explain you about the Stridhan. The term Stridhan is found in the ancient text, that property which is owned by a female. The Smriti have described certain property as a Stridhan. Manu is stated that Adhyagni Dhyavanikam Dattam cha Priti Karmani Matri Bhatri Pitra Datta Shadavidyam Stridhanam Smritam. Manu recognized 6 variety of Stridhan in Manu Smriti chapter 9 verse 194. Friends, the translation of this verse by Ganganath Jha suggests that what is given before the fire, what is given at the time of departure, what is given in the token of love, and what is received from the brother, mother, and the father has been declared to be Stridhan, which is exclusive property of a female. We may explain 6 variety of Stridhan by identifying different terminology of the chapter 9 verse 194, because verse is very clear. Adhyanikam dhyavanikam dattam cha priti karmani bhatri matri pitra praptam shadvidyam Stridhanam. The first one is Adhyagni. Adhyagni means gift made by relation or by stranger before the nuptial fire. Adhyavanikah, gift at the time of departure of bride from her parents to her husbands after marriage. Preeti Dattam, gift made in token of love by her father-in-law, mother-in-law and other elders at the time of her making obeisance at their feet. Adhyagni, Adhyavanikah, Preeti Dattam. The next is Bhrati Praptam, gift received by brother. Matri Praptam, gift received from mother. Preeti Praptam, gift received from the father. So Manu identified 6 variety of the Stridhan. Matri Praptam, Bhatri Praptam, Preeti Praptam. These are the different categories of the Stridhan. The idea of Manu is also explained by the Vishnu in Vishnu Smriti. What has been given to a woman by her father, mother, sons or brothers, what she is received before the sacred fire at the marriage ceremony, what he received on supernation, what has been given to her by her relatives. Yagyavalk in chapter 2 verse 143 is stated that what is given to a woman by her father, mother, son or brother, what is given before the nuptial fire and what comes to her in connection with her superation has been called Stridhan. Vishnu Yagyavalk also supported the idea of Manu Smriti, but the idea of Yagyavalk is also wider in the terms of Stridhan. Friends, the Yagyavalk used a word Adhyam. Adhyam means etc. In the list of the items of Stridhan, it means that he could admit more item of Stridhan than those he counted. The Vishnu Dharma Sutra has also enlisted all those items of Stridhan which are given by Yagyavalk, with the amendment that he has mentioned the gift from a son also as a Stridhan. Vishnu Dharma Sutra also added something. Gift received by the son is also considered as Stridhan. Adhived Nikadyam cha Stridhanam Parikirtitam. According to Deval, the property are allowances for maintenance, ornaments, suklas and accretions are included in Stridhan. And according to Katyayan, the wealth that is earned by a woman by mechanical art, by her own skill, or that is received through the affection from a stranger is subject to the dominion of her husband. The rest is known to be Stridhan. The Katyayan, Deval also try to expand the meaning of Stridhan. Friends, very important text on the Hindu law is Mitakshara. Mitakshara gave a concrete content to the word etc. Read by it in the Yagyavalkya Smriti, it laid down that it includes property of 5 kinds. The first, property obtained by inheritance, property obtained by purchase, property obtained by partition, property obtained by precision or adverse possession, and property found as laying ownerless. Vigyaneshwar extended the scope of the Stridhan. Therefore, scholars concluded that by giving so liberal an explanation to the Stridhan, Vigyaneshwar tried to strengthen the proprietary status of women amongst as much as section 14 of the Hindu Succession Act in the modern days. Friends, this is the idea of Stridhan. Under the Shastric Hindu law, woman is considered absolute owner of Stridhan. Therefore, no one can control woman's Stridhan. The idea of Stridhan mentioned by Manu, further expanded by Narad, Yagyavalk, Deval, and best explanation about terminology etc. explained by Mitakshara by Vigyaneshwar, where Vigyaneshwar includes many things under the domain of Stridhan, which is property purchased by women is Stridhan, property obtained in inheritance, property obtained in partition, adverse possession, or where the property is ownerless, everything comes under the domain of the Stridhan. Hindu women's property terminology is given in section 14, which also includes Stridhan. If you want to understand Stridhan, there is no explanation given in the act. The only explanation is Stridhan as prevalent before the commencement of this act. Friends, before the codification, Manu, Yagyavalk, Mitakshara and Daibhag was prevalent among Hindus, and these texts regulated Hindu personal laws. Therefore, the idea of Stridhan cannot be explained without quoting and referring the idea of Shastric Hindu law in a complete sense. And still today, these properties are known as Stridhan, and it is accepted by the court and applied in number of cases. This is the part. Hindu women's property is now a broader terminology which also includes Stridhan and plus many things, and I discuss with you about the Stridhan. Now I want to focus on section 14, property of a Hindu female to be her absolute property. Friends, the first observation about the section 14, although it is mentioned under the Hindu Succession Act but have no direct relation with law of succession, because section 14 not talks about the heir, section 14 not talks about the rules of inheritance. Section 14 just declares certain property of Hindu female as a female's property. So therefore, one observation is section 14 is not directly related with law of succession, which is the primary subject matter of Hindu Succession Act. Friends, it is important to understand that section 14 of Hindu Succession Act does not relate the subject matter of succession. Act is on succession, whereas section 14 is on the proprietary right of Hindu women, which she may get from any source, succession being only one of them. Sundari versus Lakshmi, as decided by Supreme Court in the year 1980. Stridhan is wider terminology. Property inherited by the woman is also Stridhan. It is a narrow terminology. Stridhan is wider. One aspect of Stridhan also includes property which is inherited by Hindu female. Section 14 talks about the right to property of Hindu female as discussed by Pratap Singh versus Union of India, AIR 1985, Supreme Court, page number 1694. Section 14 does not violate Article 14 of the Constitution, Article 50, subclass 1 of the Constitution, nor is it incapable of implementation. Friends, our constitution laid down the standard where special provisions may be made in the favor of women and child. Therefore, section 14 under Hindu Succession Act qualify the constitutional mandate. State have a right to enact certain laws for the providing special privilege to the women. Friends, now I want to focus on the scope and ambit of section 14. The rule laid down in subsection 1 has very wide and extensive application and has to be read a comprehensive manner. The act override inter alia the old Hindu law on the subject of Stridhan in respect of all property possessed by a female, whether acquired by her before or after the commencement of the act. This is the unique characteristics of section 14, friends. Now I want to just highlight certain other aspects related with the Hindu female's property prior to the act. The concept prior to the Hindu Succession Act, two different kind of property recognized in reference to the Hindu woman. One is Stridhan as per the Shastric Hindu law, and second is Hindu woman estate as per the Privy Council decision, as they coined Hindu women estate terminology. Means prior to the act, Stridhan is one phenomena, Hindu women estate is another phenomena. One phenomena is developed by Shastric Hindu law, another phenomena is developed by British judicial interpretation, friends. Traditionally, a Hindu woman's property rights were limited, was known as Hindu women limited estate. Friends, when we using the terminology of Hindu women limited estate, women in certain context not allowed to transfer the property. However, they are entitled to enjoy the property and claim maintenance from any property. And a woman had only limited ownership over the property. She did not have freedom to dispose of or alienate the property as she wished. Upon her death or remarriage, her interest in the property would ceased. So limited estate means Hindu woman may enjoy the property so long as she alive, or when she enter in second marriage, then she cannot retain the property of the deceased husband and cannot take the property from the family of deceased husband. Friends, now section 14, what prescribed by section 14? Section 14 is any property possessed by Hindu female, whether acquired before or after the commencement of the act, shall be held by her as a full owner thereof and not as a limited owner. For the purpose of this explanation is, in this subsection property include both movable, immovable, property acquired by a female Hindu by inheritance or device, or at a partition, or in lieu of maintenance, or arrears of maintenance, or by gift from any person, whether a relative or not, before, at or after her marriage, before, at or after her marriage, or by her own skill or extortion, or by purchase, or by prescription, or in any other manner whatsoever, and also any such property held by her as a Stridhan immediately before the commencement of the act. Section 14 subclass 1 laid down a clear rule about the Hindu woman's property. The property possessed by Hindu female, whether before the act and after the act, will consider the absolute property of female. It may be acquired by any way, before the marriage, at the time of marriage, after the marriage, or the property which she possessed as a Stridhan is absolute property of her. Section 14 broaden the scope of the property right of Hindu female. Friends, subclass 2, nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument or under the decree or order of a civil court or under an award, where the terms of gift, will or other instrument or the decree, order or award prescribed a restricted estate in such property. Subclass 2 have a different interpretation. Subclass 2 is an exception of subclass 1. Subclass 1, one hand concluded that woman is the absolute owner of the property. But section 14 subclass 2, if she received the property because of order, because of decree, because of gift, because of will, then the property rights of Hindu female is restricted only by the devices like order, decree or will, means gift. The condition of gift may prevail, condition of will may prevail over the right of the women. Section 14 subclass 1 is rule, absolute rights, and section 14 subclass 2 is restricted right, and restricted because a term is given through which she received the property. Friends, the first point is the female Hindu and its extensive meaning. The female Hindu terminology is mentioned in section 14. What do you mean by female Hindu? Female Hindu terminology also includes daughters. Every female residing in the family have a property and their property will be considered as her absolute property. So female not mean that widow or wife, it also includes mother as well as daughter also. Any female as the part of the family. The second terminology which is used in the section 14 subclass 1 is any property possessed by Hindu female. Friends, a Hindu female can claim the benefit under this section if she is in possession of the property. The word possession has a narrow as well as a broad meaning. However, the Supreme Court of India has interpreted this subsection broadly, extending its scope. In Gumma Lapuru Matada versus Setra Virawa, AIR 1959, Supreme Court, page number 577. Possessed in section 14 is used in a broad sense and in the context means the state of owning or having in one's hand or power. That possession might have been either actual, constructive, in any form recognized by the law. The widest connotation of the word is followed by many decisions of the Supreme Court. What she possessed is known as her absolute property. This is the law. What she owned is not used, what she possessed. Suppose she possessed something before the act for the purpose of maintenance, the property will be considered as a property of Hindu woman. Therefore, legislature by intention, in order to broaden the scope of section 14, used the terminology possession in spite of owning state. So what she possessed, possession may be actual possession, constructive possession recognized by the law, friends. On that basis, we can explain the idea, friends. Friends, for the purpose of section 14, possession is synonym of the ownership or title. In a case B. Muthuswamy versus Angamal, 2002, 3 SCC, page number 316, Honorable Supreme Court Observe that it has included legal possession within the meaning of possession under the provision. Therefore, where the property was owned by Hindu female, it was held to be possessed by her. Possession not mean that suppose Hindu woman owned the property but not possessed due to some reason. So what is owned by her is also considered her absolute property, and what she possessed is also considered her absolute property. The court tried to implement the mandate and intention of parliament in the form of section 14, and therefore court equated possession with title, possession with ownership. If she owned, absolute property; she possessed, absolute property. Friends, now we have certain other illustration where she possessed certain property without the title. For example, if she possessed the property in the capacity of lessee, mortgagee, licensee and the like, she would not be considered as possessed of the property for the purpose of this section. Friends, possession must be with title. If she possessed something without title in a form of mortgagee, licensee, then the property cannot be considered as her absolute property. Friends, now the next point is joint possession. It is possession under section 14 subject to the interest in the property. If female is also possessing, up to that extent the property will be considered her absolute property. But in a case of trespass, she will not considered as a owner of the property possessed by her. Friends, last possession and ownership before the commencement of this act, it will be considered that no possession under this act at the time of commencement of the act. Because rule is very clear and simple. What she possessed before the commencement of the act. If she loses possession, then the title cannot be considered, the property cannot be considered her absolute property. Friends, now I want to focus on section 14 subclass 2 is the exception of subsection 1. Subsection 1 does not apply to the property received through these methods. Section 14 subclass 1 is very clear and simple. What she possessed, her absolute property. But section 14 subclass 2 exception. In certain circumstances, the property will not considered possessed by her or her absolute property. Example, if she received the property by gift, 1, by will or by any other instrument, or by decree or order of civil court, or by an award. If this document clearly says that the woman will have only limited right over the property, then women have a limited right. It is important to note that subsection 2 uses the term restricted estate rather than limited estate. The term limited estate is an established and well recognized expression under the Hindu law and has a fixed definition. But on the other hand, the term restricted estate is not a recognized term under the Hindu law. It is not defined by Hindu Succession Act. Now we have a two terminology, limited estate and restricted estate. Hindu Succession Act use the terminology restricted estate, but restricted estate is not defined. And in India, under Hindu law, we use the terminology limited estate. When the woman held the property as a restricted estate, then woman cannot claim the absolute right over the property. Restricted estate, she does not become the full owner of the property under section 14. That will remain restricted estate. Friends, now the fundamental question is how we can distinguish restricted estate and limited estate. The difference is significant, and Justice Fazal Ali tried to resolve the conflict in a case of V. Tulsa Amma versus Sesa Reddy in the year 1977. And he observed very properly the term restricted estate has much wider import than the limited estate. The limited estate, only those limitations or restrictions which are recognized by Hindu personal law. Means limited estate admits only those limitations and restrictions which are recognized by the personal Hindu law. Restricted estate will admit any limitation or restrictions which is lawfully attached to the property, all those and only those restrictions which are mentioned in the gift or will, etc. The source of the acquisition of property will bind on the estate. Friends, I want to clarify you again about the restricted estate and limited estate. Limited estate which accept the condition only which is prescribed under Hindu law. But restricted estate means any kind of restrictions we may impose legally. It may be imposed through the law, it may be imposed by order, award, anything. Means when we think about the restricted estate, means more restrictions are there. It is submitted that the range of restriction on the restricted estate is both limited and unlimited. It is unlimited because it may cover any restrictions known to the law. It is limited because it cannot include a restrictions which is not mentioned in the source of title of the property obtained by the female. The point is very simple. Restricted estate means restricted estate except any kind of condition which is lawfully attached on the property only. Therefore, it is wider, and it is wider and narrower as you explain in different context, friends. Friends, now I want to focus on certain other expression. For example, any other instrument. How we can explain it? Any other instrument will be construed in accordance with the rule of Assumption generis. In Raghunath Sahu versus Bhimsen Nayak, the Odisha High Court observed that instrument means any instrument by which a woman gets property in which she has an interest. But what should be? There is a need of harmony between subsection 1 and subsection 2. When the property is acquired through a gift, will or any other legal instrument that expressly imposed restrictions, such property is treated as a restricted estate. In such case, the female recipient is bound by the limitation specified in the instrument under which the property is granted. So, there is a need of harmony between two subsections, friends. In the light of this discussion, we can think about certain point, how the concept of Istridhan remains relevant today, how the restricted estate different from limited estate, how can harmony be achieved between subsection 1 and subsection 2 of section 14, why is the term property possessed used in section 14 of Hindu Succession Act. Friends, before concluding the today's lecture, I want to summarize what we discussed. The fundamental question is, what is the woman's property? Because so long as we are not able to identify the woman's property, we cannot apply the law of inheritance. Therefore, Hindu Succession Act, before explaining the rules related with succession, explain the idea of property. And section 14 subclass 1 is wider, which explained that any property which is possessed by Hindu female will be considered her absolute property. The term possession is used, not ownership. If any region, if she possessed something, if the case is not comes under the exception, then the property will be treated her absolute property. But when she possesses the property as a licensee, as a margesi, then C cannot claim the absolute ownership. Otherwise, C consider the absolute owner of the property. Friends, what is the important point of section 14? Subclause 1 explanation. Subclause 1 explanation includes variety of options through which C can create the property by transfer, by anything. And what is at the time of marriage, during the marriage, before the marriage, after the marriage, C possesses the property. And very interesting point is Stridhan is also included within the domain of the property. This is also very crucial point. Means under the Shastric Hindu law, women is recognized as a holder of Stridhan. Stridhan is considered the absolute property of her. I discussed with you the Manu Smriti, Yagyavalk, Vishnu, Narad Smriti, Deval, where we, and very interesting, the discussion of Mitakshara by Vigyaneswar, where he explained that the other illustrations through which you can enlarge the concept of Stridhan under Indian tradition. This is the concept and idea. But section 16 subclass 2 is also crucial, which try to explain the idea of restricted estate. If C received the property by will, by gift, by order, by award, by decree, then C is bound with the order, award and decree. C cannot claim absolute right in that context. Therefore, section 40 subclass 1 should be read in the light of section 14 subclass 2. There is a need to harmonize because this provision is social reform provision. Therefore, wider interpretations is welcomed by Supreme Court, and therefore Supreme Court equated possession with ownership. I hope friends this information is useful for you. Thank you friends.